I have, I believe, Mr. McCallum and Mr. Davidson on the phone. Is that correct? Yeah. Okay. All right. Is Mr. present, or I know this is a rather fast setting for this hearing, but I just wanted to inquire as to whether or not he was present. All right. Yesterday, at the close of the close of the court hearings, Mr. Davidson made an objection and requested a mistrial based on a statement that Mr. Barker had made in closing argument. I denied that motion, but I asked my court reporter, Steve, to go through the record and to find the area that I believe Mr. Davidson was referring. Now, just so the parties understand where the court is, how the court is viewing this, there was in fact a motion in limine that was brought by the prosecution precluding self-serving hearsay statements. There were three statements, specifically three statements. I called them the why statements in the back of the officer's patrol car, and then another statement, I thought I was going to die. I think that was, hopefully that's a fairly precise recitation of the statements. Those statements were made in the back of the patrol car just minutes after Mr. Jones was arrested. The motion in limine was granted. I believe it was absolutely accurate. It is black letter law that self-serving statements do not fall under a hearsay exception, and I precluded those statements. Now, also, just before he was arrested, I believe I think it was Deputy LaBarre who indicated this, or it might have been someone else, another officer. Mr. Barker was referencing Mr. Jones' statement to the effect of, "It's me, I'm the only one who did anything wrong." So this is where I pick up in the argument, closing argument by Mr. Barker. He's admitting right there that he did something wrong. He's not discussing that he was justified. He's not saying that what he did was correct or right. The defendant realized in that, this is a rough draft, moment, it actually says movement here, but in that moment, that he was arrested for a reason that what he did was wrong. Now, it wasn't until later, of course, when he had an audience with the police in a police station on the record that he started talking about, well, these people were trying to kill me. The evidence was that Mr. Jones was interviewed for approximately 8 hours in this case. But the statement, now it wasn't until later, of course, when he had an audience with the police in a police station on the record that he started talking about, well, these people are trying to kill me. It's patently inaccurate. It was, he made that statement minutes after he was arrested and put into the back of a courtyard, and back of a patrol car. Mr. Barker, you're shaking your head no.
I am.
Why is that?
I am, because he did not say they were trying to kill me. That was what I was saying specifically. What he told the police at the station was that people were saying they're going to kill me. That's the thing that he never said, that they were going to kill him. It's a big difference between they're chasing me and they're going to kill me. And that was a distinction. That's why I'm shaking my head.
Okay. Mr. Davidson.
That on top of this other argument that's made to the jury that was, regardless of how the state now wants to split hairs, clearly fashioned and intended to convey to the jury that it wasn't so much later on, after he had time to think and consider what was happening, that Mr. Jones articulated anything indicating that the actions he took were self-defense. Those statements that were made in the back of the patrol car very shortly after he was arrested simply can't be reconciled with Mr. Barker's comments to the jury. And this isn't an ancillary issue. This goes right to the heart of the case, which is Mr. Jones' mindset and state of mind at the time that the incident occurred. It's just impossible, Judge, to characterize it as anything other than gross and intentional prosecutorial misconduct for you for that motion for mistrial.
Let me respond to a couple comments, Judge. First of all, the very first statement that anyone said that he said was, "I don't know." That was part of my argument yesterday. Nick Plecky then heard him say, "What did I do?" It was in that context that I was talking about. These are the statements he's making right away. That he wasn't saying I was immediately justified to everybody around him. The thing that he said to Labarra was, "Nobody did anything wrong but me." And I asked Deputy Labarra what was the context of that statement. And we had a conversation about it when he testified. The defense could have, if they wanted to, said, Rule 106, I want to hear everything around it. And the state wouldn't have objected because I've read that statement through and through. It's about 4 pages long, and it has nothing else except that statement going about what he did or why he did it. And in fact, I think Burgess actually got in the statement that he said he saw someone with a rock or something like that to Deputy Labarra. So I didn't take it out of context. That was the whole conversation that he had with Deputy Labarra. What I was saying was something different, which was when he talked to the police, he's starting to say, people are trying to kill me. And that's important because everything else that we heard about from the evidence, from all the witnesses in this case, nobody heard the word kill. And the defendant wants to say that everyone was trying to kill him. That's the important distinction here. It wasn't an intentional misrepresentation of the facts of the case. I was very careful about what I said. And so it should be denied, Judge. It's not a close call as to what the evidence is and what the rule states. So I'd ask the court to deny it.
Well, just a second, Mr. Davidson, please. I'm not certain that that's necessarily a distinction with a difference. The whole aspect about Mr. Jones' defense, for which he is on trial for first-degree murder, is self-defense. And my concern is that the jury is left with the impression that he never made any statements that could legitimately be argued as giving him a justification for the actions that he took on that night. And leaving with the jury the improper conclusion that he didn't make any of those statements until he was interviewed somewhere in that 8-hour-long interview. That's the concern I have. And that's the argument that was made. The jury doesn't know that distinction because they don't know that he made 3 other statements. I think one of them was, in fact, using the word kill. Now, I don't know what those statements are because it's been a while and I don't have the exhibits anymore. But here's what I'm going to do, because this goes directly to his self-defense and the claims that he is making of self-defense. And I do not want the jury left with the impression that he did not make any statements that could be reasonably interpreted by them as, or being reasonably argued as, claims of self-defense immediately after the incident. Now, you're saying his statements were just, within, seconds. The only thing he said within seconds of shooting these people was, what did I do, or something along those lines. The entire encounter now has moved to the statements that he made at the 8-hour interview. So you've taken the statements that he made and put them way beyond the statements he made in the patrol car by your argument. Now, here's what I'm going to do. I know you disagree with Mr. Barker, but, again.
Well, I'm just confused.
Okay, well, I don't believe I am. My concern is the jury cannot be left with the impression, and I don't believe they can be left with the impression, should be left with the impression, that the only statements he made regarding self-defense were made at the police station. That's not accurate.
I agree, Judge, and that's not what I stated.
I understand. So here's what I'm going to do. I've never encountered anything like this, and I want to give both defense and the prosecution a fair opportunity to weigh in on this and to advise me and to present their arguments. I know that this is a very fast setting, and I just sprung this on the attorneys. And so what I'm going to do is I'm going to order the jury to adjourn for today, to cease deliberations, and then I want the attorneys to give me their best memorandum on how I should handle this case and how I should rule. Now, Mr. Davidson, I'm not necessarily certain that I would still grant a mistrial, so I need to have options as to whether or not the jury should be informed by a stipulation, or the jury should be called back in and allowed to listen to those statements, just those brief statements, whether or not the jury should be allowed, whether the party should be allowed further closing argument. Based on that, I'm open to any options. So I'd like the attorneys to do that. We'll get back together at 8:30 tomorrow morning.
Judge, I have a request. Can I get the transcript that you've pulled from Steve so we
Sure.
can see exactly what was said?
Sure.
Because that makes a difference.
Absolutely.
Thank you.
Absolutely. So what I'll have Steve do is I'll have him PDF what he gave to me, and we'll email the PDF right off the PDF file to the attorneys. All right? Well, if you feel like, if you want to come up, that's fine. There are certain inherent risks of appearing telephonically with our system, I have to confess, but this is a significant issue, and so it might be best if you were present.
As soon as I ask Judge, I'm mindful of the court's time and the jury's time. It would be a preference to appear in person if the court might consider a 9 or 9:30 setting.
I'll stretch it to 9, but I don't want to go any more than that. Depending on what my decision is, I want to make sure this decision is made early.
Understood.
Okay. Thank you, folks. We stand adjourned.